Good day, everyone. We have a great show for you today. First, the roommates in the Idaho 4 murder trial. Well, their conduct is being scrutinized. And we answer a question from our viewer about why Bryan Kohberger possibly can't be the guy. The Punisher shows up to testify in the Sean Combs case. The special prosecutor, Mr. Brennan, plays cleanup after the cross-examination of the Commonwealth's expert. Another teacher in trouble. This day in legal history, our legal quote of the day, and our dumb criminal of the day. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, you can check us out on any of your favorite podcasting apps. Now, before we get to today's docket, let me remind you to go to crimetalksearch.com. Sign up for that background subscription service today. Now, remember, you can cancel at any time, but while you have that subscription, you can do as many searches of any individual in the United States as you desire. So whether it's somebody coming into your life, maybe somebody you have a dispute with, maybe somebody you're just not getting a warm, fuzzy feeling, something's not right, go check them out. So you type in their name, computer narrows it down. They conduct a background search of literally thousands of public databases across the country, and you get a report emailed to you that's going to have information related to the person that you're searching, their email address, their social media presence, their phone numbers. You're going to find out if they're married. Are they divorced? Do they have liens, judgments? Do they have a criminal history, ladies and gentlemen? Are they on one of those public registries you hear so much about? Go to crimetalksearch.com, sign up, and get that report done today on the person that you are curious about. Who knows? Maybe you're just a Crime Talk aficionado and you want to check out the players in all of these cases. Well, you can do that with crimetalksearch.com. All right, let's go ahead and get to the docket today. It's Tuesday, May 20th. All right. Now let's talk about the Kohberger case. Yes, the Idaho murder survivors' actions and inactions are under scrutiny as the trial looms. So as the August 11th, 2025 trial for Bryan Kohberger, accused of the brutal 2022 murders of 4 University of Idaho students, approaches, the actions and inactions of the 2 surviving roommates, Bethany Funk and Dylan Mortensen, are drawing some intense focus. Now, the young women, both 19 at the time, were the only witnesses to the events inside 1122 King Road home there on November 13th of 2022, when Xana Kernodle, Kaylee Gonzalez, Madison Mogan, and Ethan Chapin were all stabbed to death. Now, their responses during and after the incident, detailed in court documents, text exchange, and the 911 call are expected to be pivotal in the case, particularly by the defense, as they seek to exploit perceived inconsistencies to challenge their credibility. Now, on November 12th of 2022, the 5 roommates, Chapin, Kernodle's boyfriend, spent a typical Saturday evening together, right? Mogensen and Gonzalez visited the corner club bar and a food truck, while Kernodle and Chapin attended a Sigma Chi fraternity party. The whereabouts of Funk and Mortensen that evening remain unspecified in court records, but by 2 a.m. on November 13th, all 4 women, Mogensen, Gonzalez, Funk, and Mortensen, were back at the house. The group gathered in Gonzalez's rooms to chat, briefly considering a late-night snack before deciding to retire for the evening. By 4 a.m., all 5 roommates and Chapin were home. At approximately 4 a.m., Mortensen, whose bedroom was on the 2nd floor, reported hearing unusual noises. She overheard what she believed to be Gonzalez's voice saying, "There's someone here," followed by crying from Kernodle's room and an unfamiliar male voice saying, "It's okay, I'm going to help you." Peering out her door twice and seeing nothing, Mortensen looked a third time and saw a man described as about 5'10" or taller, athletically built with bushy eyebrows, dressed in black and wearing a mask resembling a mask of some type. He was walking toward the back sliding door. This sighting, detailed in court records, marks Mortensen as the only eyewitness to the intruder. Terrified, Mortensen began texting and calling her roommates between 4:22 and 4:24 a.m. She exchanged frantic phone messages with Funk, who was in her first floor bedroom. Now, Mortensen wrote, "No one is answering and I'm freaking out right now," describing the intruder's mask like a ski mask almost. Funk responded, "Yeah, dude, WTF," and noted Zaina was wearing all black, possibly mistaking the figure for their roommates. Mortensen also texted Gonsalves directly asking, "What's going on?" None of the victims responded as they were already deceased. Now, in a critical action, Mortensen fled her second floor room to join Funk on the first floor. En route, she noticed Kernodle lying on the floor of her bedroom, assuming her friend was drunk. Now, once together, the survivors locked themselves in Funk's room, a decision that likely saved their lives, but has been questioned for not escalating to immediate external contact. 8 hours of inaction basically went by. So over the next 8 hours, from approximately 4 a.m. to 11:50 a.m., Funk and Mortensen remained in the house, a period that has become a focal point of scrutiny. Now, records reveal Mortensen's cell phone activity during this time, including multiple unanswered calls and texts to her roommate, as well as creating, editing, and deleting images of videos. She accessed social media platforms like Instagram and Snapchat, using Snapchat's Snap Map to check Chapin and Kernodle's location. Both survivors also contacted their parents after daylight, seeking guidance as their roommates remained unresponsive. Concurrent with their fear of an intruder, neither Funk nor Mortensen called 911. Now, despite their fear of an intruder, neither Funk nor Mortensen called 911, contacted friends outside of the house, or attempted to leave during these hours. This inaction has been highlighted by Kohberger's defense attorneys, who argue in their filings that the survivors' failure to seek immediate help undermines their reliability. The defense notes neither of them left the house. Neither of them called friends, family, or law enforcement for help, suggesting this delay could cast doubt on their accounts. Now, the 911 call and discovery at about 11:50 a.m. with no response from their roommates, Funk and Mortensen took a decisive step by inviting two friends over to the house. Accompanied by a friend identified as HJ, they'd ventured to the second floor where they discovered Kernodle's body. This prompted a 911 call from Funk's phone just before noon. The call, marked by panic and confusion, included heavy breathing and crying as survivors and their friends passed the phone around. They reported a roommate passed out and not waking up, with one caller mentioning, "Oh, and they saw some man in their house last night." The delayed call, while distressing, followed hours of uncertainty and fear. It reflects on the survivor's struggle to process the situation. Now, after the murders, Funk and Mortensen were quickly ruled out as suspects, but have faced intense online scrutiny and rumors, particularly regarding the 8-hour delay. Now, both women testified before the grand jury in spring of 2023, with Mortensen providing a detailed account of the intruder. They have since maintained a low profile, transferring to different universities and getting matching tattoos to honor their slain friends. Funk faced a defense subpoena in June of 2023, which her attorney contested, leading to an agreement for a private interview in Nevada. The content of that interview remains undisclosed, but it could play a big role in the defense strategy. Now, as star witnesses, Funk and Mortensen's actions, texting, locking themselves in Funk's room, and eventually calling 911 and inactions, particularly the 8-hour delay, will be closely examined by jurors as well as the defense. The prosecution will likely emphasize their panic texts and the 911 call as evidence of the night's terror, corroborating Mortensen's description of the intruder. Her sketch of the mask and the physical description partially align with Kohberger, supported by the evidence of his alleged purchase of a similar mask. However, the defense is poised to challenge the young women's credibility. They have questioned Mortensen's state of mind, citing her admission of being in a dreamlike state and possibly intoxicated. The defense also contested her bushy eyebrows description, arguing it may have been influenced by artwork in her room, though the Judge Stephen Hippler, upheld its relevance, noting her remarkably consistent account across 5 police interviews and grand jury testimony. The delay in calling 911 and the survivor's decision to remain in the house are likely to be central to the cross-examination, with the defense suggesting these choices reflect unreliable perception or memory. So, as the actions of Funk and Mortensen, their frantic texting, seeking safety together, and eventually alerting police reflect the paralyzing fear of that night, while their inaction, particularly the delayed 911 call, have fueled some debate. Now, as they prepare to testify, their detailed accounts and their emotional weight of their text exchanges will offer jurors a vivid picture of this horror and tragedy. Now, despite facing public and legal scrutiny, their resilience as survivors underscores their critical role in seeking justice for their friends in one of the most high-profile trials in recent memories. Ladies and gentlemen, the judge has described both of these young ladies as victims. They have a place in the courtroom reserved for them if they choose to remain under the Idaho Victims Bill of Rights. Now, I've heard people say crazy things that they were involved, they should have done this, they should have done that. Or you know what? Maybe they were just scared 17, 18-year-old kids at the time and really didn't know what to do, didn't want to call the police to get anybody in trouble and overreact and all those things that young, naive people do at the time. I don't think that there is any malice or ill motive on either one of these young girls' testimony at all. Frankly, this is simply a situation where I think they were just young, dumb, scared, didn't know what to do. Probably in their wildest dreams never would have imagined in a house where people come and go quite often and frequently for parties and things of that nature that anybody would have committed a quadruple homicide while they were in the house. I don't think they ever thought of that. They will probably always second guess what they did, but they're going to come to court and tell the truth. Now, the question is, will it stand up under cross-examination? That is yet to be determined. But the defense is going to have a difficult time, and I don't think they should be attacking these young ladies on the witness stand. If anything, they should be treating them with kid gloves for doing that. You can certainly call out any inconsistencies, but you have to do it nicely. All right, ladies and gentlemen, let me also continue on the Kohberger matter. So yesterday I was reviewing comments as I was enjoying a fine cigar. And one of these comments stuck out. It's from a Deborah Higginbottom, I believe. And it says, "I have too many questions. How can one have no motive, no criminal background, no knowledge of the victims, no stalking per the state attorney Thompson, no knowledge of the home, no dexterity with knives per past employment, be a crime iCloud forensic doctoral student, and drive your own car and carry a cell phone to a crime, let alone parking a few feet away and entering a dark unknown house with 5 cars, 6 people, barking dog, and do a crime in minutes, plus clean up all while holding a knife and using different weapons, techniques, and weapons. And how about this? He was a vegan, hated blood and meat, and wouldn't even want to eat food that was cooked with meat juices, and I do not believe he wants to be covered in blood. No DNA was found in his car, home, or office. Mention the sheath. No one else thinks it's weird that it was found underneath Madison Mogen's blanket when they reported last week that there was no resistance from MM, who was likely passed out or sleeping. This means BK would have to fight 3 young, strong adults while holding a slippery knife and still manage to kill them. And what about Dylan not mentioning that he should be panting hard while holding a bloody knife, but she also saw his eyebrows? We won't mention the 8-hour delay, crime scene cleanup, the questionable trace DNA on a brass button for a day, and no IDing BK from Dylan. How many more things equal reasonable doubt? Let the trial play out. People need to see both sides. I agree. The trial will have to play out. But let's kind of go through a little bit of this, all right? And, let's kind of respond to it. And like I said, we know what the evidence is that's been released. There's a lot of stuff we don't understand. But this was my kind of general response to this. I understand your concerns about the Bryan Kohberger case. There are indeed many questions surrounding the evidence and timeline. Let's kind of break it down logically. Now, the lack of clear motive, criminal background, or direct connection to the victims does raise questions, but it's not uncommon in some cases for the element elements to be unclear initially. The prosecution might be relying on circumstantial evidence like the cell phone pings near the crime scene, the white car, and the knife sheath with Kohberger's DNA. While no other DNA was found in his car, home, or office, the sheath's DNA is a significant piece of evidence tying him to the scene. It is possible the sheath was overlooked during the chaotic nature of the events. The vegan detail and the absence of blood or meat consumption might suggest he took precautions to avoid leaving biological evidence, though this is obviously somewhat speculative. The lack of resistance from the victims could indicate they were caught off guard, possibly asleep, which aligns with the early morning timing. Kohberger, as a criminology student, might have had the knowledge to minimize evidence, though the 8-hour delay in crime scene cleanup concerns are valid. Trace DNA, like on the brass button, can persist despite cleaning attempts. Now, Dillon limited the description, and the absence of more direct identification are puzzling, but trauma can affect memory and perception. As for the physical challenge of the overpowering multiple victims, a surprise attack with a knife could explain this, especially if the victims were not fully alert. This case isn't airtight, and doubts highlight gaps that the defense might explore at trial. Both sides will be heard to get to clean up the picture, so to speak. So let's see how the evidence holds up in court. That was my response. But I think it's valid. Listen, we all do not have complete and total access to the all the evidence in this case. Frankly, I hope the case doesn't result in a guilty plea, if one is even extended to Mr. Kohberger. But if he wants to exercise his constitutional rights to proceed to trial, then he should be allowed to do that and let the world see, just like Judge Hippler has said, this needs to be televised. It needs to be open to the public. So regardless of whatever the decision is, people can say, yes, I understand how the jury reached that verdict. But I just thought that was kind of, I get lots of people that say, oh, Bryan Kohberger, is completely innocent. There's too much doubt, etc. And yes, it can all be explained away, just like you can say, well, this is enough to raise reasonable doubt. This is enough to raise reasonable doubt. Well, we'll just have to wait and see if it is enough to raise reasonable doubt, or whether the government will be able to carry their burden of proving each and every element of the offense beyond a reasonable doubt. Next on the docket, an update on the Sean P. Diddy Combs case. That's right. Just the other day, and they finished up the testimony. David James, Combs' former personal assistant from 2007 through 2009, provided insight into Combs' controlling nature. James testified that Mr. Combs kept an embarrassing video of him dancing at a New Year's Eve party to assert dominance, threatening to release it publicly. And he describes Combs' obsession with consistency, such as demanding ketchup at every meal, and revealed Combs carried a medicine bag containing Viagra, diet pills, Percocets, and ecstasy pills, some shaped like former President Obama's face. Mr. James recounted a 2008 incident involving rival Suge Knight, where Combs allegedly armed himself with guns and instructed James to drive to confront Knight, prompting James to resign due to safety concerns. Now, James also noted that at a hotel in New York, Combs' favorite place to stay, where staff provided him with a key for convenience. Then we had Sheree Hayes, a.k.a. The Punisher. He's a male escort. Mr. Hayes, known as The Punisher, testified about the encounter with Combs and Ventura, hired to create sexy scenes. He described a 2020 meeting at the Trump International Hotel, where Ventura instructed him to apply baby oil mutually, while Combs, veiled and nude, observed. Hayes was paid $800 initially, and initial $1,200 after that, with strict instructions not to acknowledge Combs. He estimated 8 to 12 such encounters, those details of which were put forth in a 2020 book that he wrote about the experience with erectile dysfunction and mental health issues. Now, Cassie's mother, Regina Ventura, testified about Combs' threatening behavior towards her daughter. She recounted a 2011 text from Cassie warning that Combs planned to release explicit sex tapes and harm her and rapper Kid Cudi. Regina described taking about $20,000 of home equity loans to repay Combs after he demanded compensation from Cassie's relationship with Cudi, though the money was later returned. She also witnessed Combs' aggressions, including an incident where he berated an employee for laughing and another where he took Cassie's phone, prompting Regina to call the police. The defense declined to cross-examine her. Anyway, the prosecutors are presenting some graphic evidence, including photos of Ventura's injuries and images from alleged freak-off setups, though the judge denied media requests to view the related videos in open court, citing the risk of re-victimization of Ms. Ventura, as well as other unnamed witnesses. Now, the defense conceded Combs has a temper and a panache for violent outbursts and drugs, but argued that these constitute domestic violence, but they're not sex trafficking. Anyway, the attorneys say that Combs' swinger lifestyle involved consenting adults, asserting that kinky preferences do not equate to criminality. Now, Mr. Combs apparently was quite chilly this morning, and then the judge turned up the heat in the courtroom. See, ladies and gentlemen, this is why you don't do all this weird, kinky stuff, because if it does turn out to be weird and kinky, it's usually going to wind up in the public. How would you like your private life completely on display in the public forum? You probably wouldn't want to do it. What's the best way to avoid that? Don't do weird stuff like that. You can do what you want, but just understand if it gets out, and it's probably being recorded, it's going to get ugly. Next on the docket, let's talk about the Karen Read trial. So after having his credibility questioned by the defense, the digital forensic expert Shannon Burgess is set to return to the stand today. Was set to return to the stand today in the Karen Read murder trial. Now, Burgess of the accident reconstructionist, biomechanic, and digital forensic company Aperture testified Monday about data the prosecution hopes will pinpoint a timeline of when they believe Read allegedly hit John O'Keefe with her car. But the defense attorney, Robert Alessi, attempted to poke holes in Burgess's credibility, accusing him of misleading clients about his academic credentials. They said his biography on the Aperture website said he graduated with a bachelor's degree in mathematics and business administration. But he acknowledged under cross-examination that while he has been pursuing the degree for the last 17 years, he does not quite yet have one. Now, intense scrutiny, obviously, in this particular case for the retrial of Karen Read, accused of second-degree murder in the death of her boyfriend, John O'Keefe. Like I said, this all continued basically yesterday. On cross-examination, the redirect examination of 2 days on May 19th and 20th, his testimony centered on vehicle data and timeline reconstruction, was met with sharp challenges from the defense, raising questions about his credibility, methodology, and the reliability of his findings. Now, the special prosecutor, Brennan, called Burgess to the stand to present data extracted from Read's SUV, which prosecutors allege struck O'Keefe in January of 2022, leaving him to die in a snowstorm. Now, Burgess, specializing in vehicle and cell phone forensics, testified about two key trigger events recorded by the Lexus TextStream system, a three-point turn at 12:23:59 a.m. and 12:24:07 a.m. and a backing maneuver between 12:32:04 a.m. and 12:32:12 a.m. He synchronized these events with O'Keefe's iPhone data, noting that the 21 to 29 second clock variance between the vehicle system and the phone system, which showed O'Keefe's last interaction locking the phone at 12:32:09. Burgess argued that this timeline supports the prosecution's claim that Read's SUV struck O'Keefe during the reverse maneuver, and Burgess explained that the initial data extraction missed critical information due to an overlooked micro SD card in the SUV's infotainment module and damage to other modules from overheating during a chip-off process. Now, he discovered the vehicle's power on and power off timestamps, which he cross-referenced with surveillance videos to verify the timeline. Burgess emphasized that his analysis was strictly limited to the data and the science, and clarified that the SUV's clock was accurate to the minute, not the second, necessitating manual synchronization adjustments. Now, in cross-examination, credibility and methodology defense attorney Robert Alessi began his cross-examination of Burgess on May 19th and continued today with a relentless focus on undermining his credibility and the validity of his reports. Now, Alessi first targeted Burgess's educational credentials, revealing that he doesn't have a bachelor's degree, as posted on a company website as well as his LinkedIn profile. And Burgess admitted he's been pursuing that degree for 17 years. Hey, who hasn't, right? Anyway, Burgess countered that he has never misrepresented his credentials in court, and that his LinkedIn page listed as an expected graduation date has never been updated in years. This exchange prompted visible reaction from jurors, with some appearing to wince and take notes, suggesting the attack on Burgess's credibility resonated. Now, Alessi, then scrutinized Burgess's report, highlighting differences between his January 30th, 2025 report and the May 8th, 2025 submission. The January report omitted mention of tech stream trigger events and used the term incident rather than collision. While the May report introduced the trigger event and referenced a collision based on the Massachusetts State Police crash report, Alessi accused Burgess of keeping the initial report purposely vague by noting only a clock variance without further analysis, a claim that Burgess denied. The defense argued that the May report, issued mid-trial, constituted an ambush and shifted a crucial timestamp, impacting their strategy for the defense. Burgess maintained that the supplemental report clarified, not altered, his original findings, prompted by discrepancies in defense experts' reports. Now, Alessi further challenged the interpretation of trigger events, eliciting Burgess's admission that the SUV black box data box does not independently indicate a collision. Burgess confirmed that trigger events, of which there were approximately 30 over 8 months, could result from actions like slamming on the brakes or performing a three-point turn, not necessarily crashes. Alessi pointed out that Burgess failed to apply a 3-second offset between the SUV's ignition and infotainment system and ignored user activity on O'Keefe's iPhone after the locked event, potentially undermining the prosecution's timeline. He also suggested confirmation bias, noted that Burgess labeled the case a homicide in November of 2024 in a CV footnote before completing his testing. Burgess defended his methodology, stating he used the three-point turn as a synchronization anchor to avoid reliance on call logs measured hours later. So, Brennan then gets up today for some damage control, and he conducted a redirect examination to rehabilitate Burgess's testimony. Brennan addressed the educational discrepancies, asking if Burgess had ever claimed a bachelor's degree in court. Burgess replied no, and noted his testimony in multiple cases across 4 or 5 states without prior challenge to his credentials. Brennan referenced well-known figures like Bill Gates and Steve Jobs, who succeeded without degrees, to downplay the issue. He also had Burgess clarify concerns about defense expert report, particularly its handling of clock synchronization, reinforcing that Burgess' supplemental report was a response to those inaccuracies. Burgess reiterated that his analysis accounted for the 3-second delay and maintained the integrity of the timeline. Anyway, Burgess' testimony is central to the prosecution's effort to pinpoint the moment Reed's SUV allegedly struck O'Keefe and the data aligning the reverse maneuver and O'Keefe's phone activity within seconds. However, Alessi's cross-examination damaged his credibility by exposing resume inaccuracies and raising doubts about the specificity of the trigger event data. Now, the bottom line is, ladies and gentlemen, there's no perfect witness. Okay, there's no perfect case. There's no perfect direct. There's no perfect cross-examination at all. But somebody putting something on their resume is certainly something to go after, but the defense did not just absolutely eviscerate his findings as it related to the data and saying he didn't account for 3 seconds. At the end of the day, ladies and gentlemen, the data, the phone syncing, whether we're talking a few seconds here or there, something happened. By Karen Reed's own admissions, she was intoxicated. She then admitted she hit him. Did I strike him? It's kind of, I don't know. Once again, what are we on, day 18, I think, of this trial? Day 19, Frank, the hardest working man in show business, just told me. 19 days for basically a hit and run by a drunk driver. Unbelievable. Now, good lawyering on both sides. I think Brennan doing a great job. I think the defense is a little bit on their heels. They had their best shot. First trial didn't quite come through for them, and the defense and the judge failed to ask for a mistrial or a not guilty, entering on the charges in which the jury had reached those findings. So the defense, like I said, it's never as good the second time around when you don't have that element of surprise. And, when you give the other side another year to go back and fix their problems. I don't know. It's like a tennis match, right? Somebody scores a point, next one scores a point. So far, I don't think there's any huge aces from either side. We'll see what the jury decides. Next on the docket, another teacher's in trouble. DeSoto County in Mississippi is, there's a lot of talk going on down there. Probably saying, oh, she's so precious. For the arrest of Natalie Elizabeth Wright, a 31-year-old former special education teacher at the Lewisburg High School. And guess what she's charged with? Felony fondling by a person in a position of trust. That's right, Miss Wright is accused of engaging in inappropriate contact with an underage student, including public displays of affection in a Taco Bell parking lot and a church parking lot as well. Now, the court documents reveal a troubled pattern of behavior, right? Miss Wright, who also tutored the victim, allegedly committed acts driven by sexual desires with the student who is under the age of 18. Now, witnesses reported seeing Miss Wright kissing and making out with the student on April 21st, weeks after her resignation from the school district on April 3rd. The resignation followed the discovery of the inappropriate physical contact, ongoing communication, and Wright driving the student to school in her own personal vehicle. Some compelling evidence emerged from Wright's own home, where her husband, Adam Wright, reportedly obtained video and audio recordings of her admitting to kissing the student multiple times during private tutoring sessions. These admissions, combined with the witness's testimony and her role as a trusted educator, led to her arrest. Well, Miss Wright, who has no prior criminal record, I guess you never know where it's going to come from, do you? Was released on a $200,000 bond and is scheduled back in court on June 6. The charge, a serious felony under Mississippi law, carries the potential of a significant prison sentence if she is convicted. Obviously, the standard stuff where the school says we're shocked and surprised and we never saw this coming and we decline further comment and all that familiar stuff, right? Anyway, Miss Wright was apparently quite familiar figure in the school community, participated in PTA events, and her arrest has left residents grappling with the betrayal of the trust by the once respected educator. You just never know. Here we have a woman with no criminal history and starts sexually assaulting young male students. My God. I just don't believe it. You can't believe it. I guess that's reasonable doubt, right? Oh, unless you got video physical evidence, right? Ooh, admissions, right? Ooh. Yeah. The no criminal history, I've represented lots of people done some really bad things with no criminal history. So going back to our Kohberger discussion, I just don't think that that does it. Now, don't get me wrong. If you have a history of small stuff, yes, normally leads there. But no criminal history doesn't mean you still can't swing for the fences and hit a home run. Next, this day in legal history, May 20th, 1908, the Attorney General Charles Bonaparte was finalizing the creation of the Federal Bureau of Investigation. That's right, the FBI, established in July to combat federal crimes. This marked a shift to centralized law enforcement. On this date, May 20th, 1940, the United States Supreme Court held that the Free Exercise Clause of the First Amendment applied to states' governments in the Cantwell v. Connecticut case under the incorporation doctrine, which applied the protections of the Bill of Rights to the state governments through the due process clause of the 14th Amendment. Those important clauses that they say, obviously Bill of Rights is an extension, limitation on the federal government's powers, but it didn't limit the state's powers. But they said, nope, under the 14th Amendment, we're going to allow them to have the protection, these fundamental rights, ladies and gentlemen, the first, second, fourth, fifth, sixth, eighth, all applied to the states. Next, on this day in 1940, the Smith Act prosecutions planned. That's right, the Department of Justice was preparing cases under the Smith Act criminalizing subversive activities. These prosecutions targeted communists, shaping Cold War era free speech debates. And on this date in 1968, President Lyndon Johnson signed the Omnibus Crime Control and Safe Streets Act, establishing the Law Enforcement Assistance Administration to fund police modernization and crime prevention, which is code for collecting the money and doling it out. And on this date in 1977, the Department of Justice wrapped up the Watergate-related prosecutions with several Nixon aides convicted. The scandal led to the reforms in campaign finance and government ethics laws, and ultimately the resignation of President Nixon. And on this date in 1982, Pretrial Services Act was signed on May 20th, 1982. President Ronald Reagan signed the Pretrial Services Act, expanding federal pretrial services to all districts. It improved bail processes and reduced pretrial detention abuses. No, it hasn't in federal court. Basically, most charges are brought up there have a rebuttable presumption case, and that means it is presumed that somebody is a danger to the community and a flight risk, and it's very difficult for most people to get out of custody in a federal court case unless it's maybe some white-collar crime case. I wonder why. That's maybe because the people writing those laws are more likely to be charged with those type of laws than they are with, maybe bludgeoning, murder people with guns and shooting out and selling drugs, possibly. I don't know. Let me know what you think. Next, quote of the day. The law is not a series of calculating machines where definitions and answers come tumbling out when the right levers are pushed. Said by William O. Douglas. This quote is attributed to Supreme Court Justice William Douglas, highlights legal interpretation's nuanced and human-centric nature. It suggests that the law requires judgment, context, and discretion beyond mechanical applications, like the federal sentencing guidelines, for example. Anyway, Douglas was known for his advocacy of individual rights, underscoring the complexities of jurisprudence, making this an insightful reflection in today's legal considerations. And finally, our dumb criminal of the day. A Fort Myers, Florida man faces felony charges for shooting his neighbor's cow. That's right. Hung Trin, a resident in Fort Myers, was arrested after allegedly shooting a neighbor's 2-year-old calf 5 times when it strayed onto his property. Now, the incident has drawn attention to the growing tensions in Florida's rural community where residential and agricultural zones intersect. Now, deputies from the sheriff's agricultural unit responded to the scene and discovered the calf with gunshot wounds to its gut, chest, and rear leg. The injuries were deemed untreatable, and the animal was euthanized. Now, the calf's owner informed authorities of a prior conflict with Mr. Trin, who had reportedly threatened to shoot livestock that wandered onto his land. A search of Trin's property uncovered a .22 caliber firearm in a shed believed to be the weapon used. Trin was charged with animal cruelty and grand theft of a commercial farm animal. Now, the sheriff there condemned the act, stating there will be accountability for taking your frustrations out on innocent animals. In this case, multiple felonies and jail time. We know how much these animals mean to our farming community, and we will not tolerate these actions. Now, Florida law requires livestock owners to maintain secure fencing, but authorities stress that lethal force was not a lawful response to the situation, and the investigation continues as officials further assess the case. There you go, ladies and gentlemen, our dumb criminal of the day, Mr. Trin. Shooting a little calf with a .22? You're not going to kill a calf with a .22? Shooting it from a distance? Are you kidding me? That's just dumb. Anyway, Mr. Trin, you are a dumb criminal of the day, and we feel sorry for the 2-year-old calf. That's all we have for you today. Thanks for watching. We'll see you next time on Crime Talk. And remember, the Constitution matters.